This is a question that arises in everyone's mind. Doctors are supposed to treat patients. Doctors are supposed to take care of patients, and that is what they do. Yet there are times when law intervenes and punishes a doctor. Next slide, please. Next slide.
Yes, sir. Next slide. Yes, sir. Go on.
This is a hard fact. A doctor can be held negligent under the criminal laws of India. Doctors can be held negligent under civil laws of India. When a doctor is negligent, a patient can sue a doctor before various courts. The patient can go before an ordinary civil court and file a suit for damages. The patient can go before a criminal court and ensure that the doctor is punished. The patient also has the option of going before the medical council and starting disciplinary proceedings against the doctors. If the doctor or the hospital happens to be a government hospital, then the option of approaching the writ courts, that is the higher constitutional courts, the Supreme Court of India, the High Court of India is there, as well as the Human Rights Commission. But most of the cases that are filed against doctors are filed in consumer courts. What happens when a doctor is held negligent? Doctor can lose license to practice. Doctor can be imprisoned. In fact, under section 304A of the Indian Penal Code, if a death has occurred due to negligence, 2 years is the maximum imprisonment that the doctor may have to undergo. Doctor may have to pay a fine. Fine in a criminal court, damages in a civil court, or the doctor may have to pay compensation, and that too in a consumer court. Next slide.
Yes, sir.
The moot question is, why does the law punish doctors? Is it only to compensate the patient? And that is all. That is what we are observing day in and day out. Patients, nearly 100% of the cases against doctors are filed in consumer courts, where the only remedy available to the patient is money. Or is it that law intervenes so that the patients or their attendants don't take law in their own hand? Something that in legal parlance, in legal jurisprudence, we call as doctrine of retribution. This would minimize violence against doctors. Or is it to discipline doctors, have a deterring effect, so that doctors discharge their duties in a proper and legal way? Or is it something else? Next slide. Friends, the only purpose why law punishes a doctor is to ensure and enhance patient safety. There is no other purpose for law to intervene when a doctor treats a patient, but to ensure that the patient's safety is not compromised in any way. Next slide. The cost of legal unawareness for a doctor is monetary loss. Yes, because he may be asked to pay compensation, he may be asked to pay damages, he may be asked to pay fine. Even a bigger loss is that the patient may go to media, the doctor may lose reputation. For every professional, reputation which is earned over years and years has to be preserved and enhanced. One simple case of medical negligence and the reputation of the doctor is tarnished. But the biggest cost of legal unawareness as far as doctors are concerned is that the patient's safety is compromised. This is simply unpardonable. Doctor friends, it is therefore absolutely necessary, legally mandatory, that each and every doctor must remain legally updated and must follow the legally correct and best practices. This will ensure reduction, minimization of accidents, of errors, of mistakes, and thus enhance and ensure patients' safety. Next slide. Next slide, please.
Yes, sir. Next slide.
Having said that, the next question from a doctor's perspective is, how does a doctor keep himself or herself updated? There is a written law for doctors in India. The Medical Council of India, regulatory authority, it has drafted, and the Indian Medical Council Professional Conduct Etiquettes and Ethic Regulation 2002. It has been published in the Gazette in April 2002. The last amendment to this law has come in February 2016. It is a simple A4 sized 6-page document, not very hard to read, to understand. After all, it has been drafted by Medical Council of India, a body of doctors themselves. This is the least that each and every doctor must do to keep himself or herself legally updated. Next slide, please. Let us now discuss medical negligence. As far as reported cases in India go, they point out that nearly 2/3 of the cases in India on medical negligence are filed due to improper consent or improper documentation. Friends, it is very important to understand that this points out to one basic flaw that the medical fraternity today suffers from, and that is the procedural aspects of law are not at all adhered to, are not known, and therefore not adhered by the medical fraternity. It is important, therefore, for doctors to know law, to keep themselves updated on law, especially the procedural aspects. Next slide, please. Next slide, please. With that, friends, let us update ourselves with some very recent but significant changes that have happened in law today. The most significant change that seems to be happening is that the experience of a doctor is being taken into account by courts in cases of medical negligence. Earlier, only the qualification of a doctor was questioned. If the doctor had the requisite qualifications, then he was not held negligent. But slowly courts seem to be moving towards experience also. The day is not far when the courts will ask doctors whether in a high-risk case or a critical patient, the doctor had the requisite amount of experience before accepting the patient or not. As of today, courts are pronouncing judgments holding doctors not negligent if they have bigger number of experiences. Second significant change that we have been observing, and this has been observed for the last 2 years, is that allegations of medical negligence are being made only to avoid payment of fees. And this can be seen very clearly. Even courts are observing, commenting against patients, doctors, hospitals, and even patients need to know about this. Patients are increasingly suing only hospitals and not doctors. This is a very recent trend. Nearly 80% of the cases that are filed today, hospitals are invariably involved in them. This was not the case earlier. General practitioner, family physicians, doctors practicing in their consulting chambers, they were also sued. But today it seems that majority of the cases are the ones where the patient has visited a hospital, consulted a doctor in the hospital or undergone surgery in a hospital, and thereafter he is suing the hospital and the doctor. One very significant aspect, very noticeable, that we have observed is surgeons being sued for going on planned leave or remaining absent during the post-surgery period. Surgeons need to know that their duty does not come to an end merely by performing the surgery. Post-surgery care is an integral part of the surgeon's duty. Any failure to provide post-surgery care is viewed adversely by the courts. Emergencies, of course, would be an exception. And emergencies of the doctors, emergencies of the patients. If an emergency patient comes in and the doctor is going on a planned leave, the doctor can very well disclose this fact to the patient. And thereafter, if both the patient and the doctor agree, the doctor can accept the patient, perform this surgery, and hand over post-surgery care to competent substitutes. In case the doctor has an emergency, the doctor can leave, and the emergency obviously has to be a personal emergency. The doctor can leave the patient and proceed on personal emergencies. The only precaution that doctor needs to take is to see that a proper, competent, qualified, experienced substitute is there to take care of the patient. Allegations relating to misdiagnosis, delayed diagnosis, they have doubled. They are increasing at a very alarming rate. Today, patients are even questioning doctors on the selection of the other consultant when a patient is referred to another consultant. The patient's allegations are, hey doctor, why did you refer me to Dr. X? You wanted a cardiac opinion, you wanted an anesthetist opinion. I could have got it from any doctor. The courts have refrained till date from holding any doctor negligent or deficient in service for referring a patient to a particular doctor, but such allegations are surfacing with alarming rate. When a doctor happens to be a patient, or when a relative of a doctor happens to be a patient, then the probability of such patients going to court increases manifold. This is one very interesting aspect that we have observed in the last few months. Next slide. Friends, with all these talk about medical negligence, the air of apprehension that is there, the atmosphere of distrust which is prevailing, the relationship between a doctor and a patient is at an all-time low. I'm also aware that the apprehension, anxiety amongst doctors about legal problems assure doctors that law in India, legally speaking, technically speaking, favors doctors and not patients. Two simple yet legal aspects to buttress my contention, my submission. Number one, proving negligence in a court of law is a tough job for a trial lawyer. If you have a friend who conducts trials, do ask him if he has conducted a trial in a case of negligence. A civil trial or a criminal trial, it hardly matters. And if he has conducted a trial, he will be ready to share his experiences, and at the end of it, he will admit before you that conducting trial in a case of negligence happens to be the toughest job for a trial lawyer. The reason is very simple. Negligence has nothing to do with the overt actions. It is simply a state of mind. A person may be diligent, he may be careless, he may be negligent. The line dividing negligence and carelessness is far too thin. The second point. We in India, we follow English law. World over, Commonwealth countries, they follow English laws. There is another side which is the American system also. The English system happens to be pro-professional, whereas the American system happens to be pro-victim. In America, when an injured person comes to the court, law presumes that the doctor was negligent. Legal proceedings of an adverse outcome start on the footing that the doctor or hospital was negligent. That is not the case in India. That is not the case in England. Law here presumes that if a qualified professional has performed his or her duty, it has been performed correctly. It has been performed legally proper. If the standard of care that law expects has been followed. This is a big difference. Let me illustrate it. A patient has lost his eyes. He goes in before the American courts. He simply has to make one small statement. I had undergone a surgery, and this was the doctor who had performed surgery. This is the adverse outcome. Law presumes that the doctor was negligent, and it is for the doctor then to prove in the court that he had performed his duty diligently. It is for the doctor to bring medical records. It is for the doctors to bring medical literature. It is for the doctors to bring witnesses. And if the doctor fails, there is a grand jury sitting out there to punish the doctors with heavy compensation. In India, that is not the case. The moment a patient goes to the court and shows his injury, the first question that the court asks is, "Hey doctor, are you qualified?" And once the doctor shows his qualifications, the court presumes that the doctor was not negligent, and it is for the patient to positively prove that the doctor was negligent. The onus, the burden to bring medical literature, medical records, witnesses is on the patient and not on the doctor. The doctor or the hospital can simply keep quiet. So doctors need not be unnecessarily anxious, apprehensive about medico-legal problems. They need to keep themselves updated on laws. That is the need of the hour. Thank you.
First question is from Dr. Vivekanshu.
Yeah.
Why nurses are not punished by Indian legal system even after gross medical negligence leading to death of a patient? Example, in Spring Meadow Hospital case, unqualified nurse giving wrong injection causing death of a child later.
Dr. Vivekanshu, actually it is a legal doctrine known as the doctrine of vicarious liability, where the master of the ship happens to be responsible for all the faults, for all the wrongs that have been done on the ship. The doctor in this case happens to be the master of the ship. If you minutely dissect this Spring Meadows case, you will find that ultimately the nurse was appointed by the hospital. The hospital had no job to appoint an unqualified nurse, and if the hospital has appointed an unqualified nurse, then it has to bear the consequences, pay compensation to the patient. Yeah. Next question.
Next question is from Vivek.
Yeah.
In one of your slides, you have mentioned that remaining legally updated and correct is not an option, but a necessity for all medical practitioners. But I am not aware of any avenue or source for updating the doctors with this information regularly. What is the way out?
The first way I have already shared with you, that at least the Indian Medical Council regulation that is made or drafted by Medical Council of India, doctors need to be aware. That is the least that they should do. Then there are CMLEs which are being organized by medical associations, which they should attend. Other ways of keeping themselves updated, one of them is we at the Institute of Medicine and Law, we bring out a monthly law reporter for doctors. They can subscribe to it. There are courses, various institutions are holding it. They can enroll for one of these courses. So there are avenues today in India by which doctors can keep themselves and should keep themselves updated.
Next question is from Rajiv. Sir, is it not that the cost of healthcare is so high in US because of American laws?
Yes, certainly. And that is what should be thought of by the policymakers of this country, whether we can afford this high cost of compensation. Because ultimately, if the compensation is high, doctors will be bound to increase their premium. Ultimately, all this is going to be passed on to the patient. There is another aspect also. Doctors in India today have started practicing defensive medicine. Defensive medicine means that the doctor is prescribing an investigation or a medicine not because the patient needs it, because the doctor needs it for his or her comfort, defense, tomorrow in a court of law. So in a developing nation, a poor nation like India, whether we can afford that, this is the moot question that the policymakers of this country certainly need to take cognizance of. Yeah, Akanksha.
Next question is from Rajiv again. What can be done to bring down the incidence of violence on doctors?
See, the first thing is we have to educate the patient when the patients are not patients. That's the very important aspect that needs to be addressed. It needs to be addressed by doctors, by NGOs, by media. Ultimately, violence of doctors is going to lead to nowhere. And the biggest loser in this case happens to be the patient and none else. So we have to educate the patient that medicine does not have remedy for all ills. Modern science has hardly been able to decipher human body completely. Medicine accepts there will be complications that cannot be explained. Simply because you have paid money, simply because you have paid money for one of the best doctors, you cannot be assured of cure. What you should insist on is care. Whether proper care was was taken or not, whether proper standard of care was there in the treatment or not. If that is there, then obviously the results may or may not come.
Next question is from Lavina. The Indian Medical Council regulations of 2002 state that if a doctor receives gifts more than 1,000 rupees, he would undergo censure. Does it mean that they are allowed to receive gifts up to 1,000 rupees from companies?
That is what the law says anyway, Akanksha. This does not happen to be the subject at hand today. Ethically, it is wrong for the doctor to receive even a gift of 1 rupee. But as the law stands today, below 999, the doctors can accept it. I am purely on a legal footing.
Okay, going on our next question from Sanjay. For non-allopathic doctors, why it is the state council is deciding whether they should be allopathic medicine or not?
No, their state councils cannot decide whether they'll be able to give medicines or not. In some states, the state government, keeping in view the extraordinary condition that exists, the paucity, the scarcity of MBBS doctors, the state government has come out with notifications that certain medicines, certain treatments can be done by non-allopathic doctors. The councils of Ayush or the state medical councils can certainly not take this decision. You are misinformed on that.